Was the restraint of George Floyd consistent with police policy? And 2, causation. Did they actually cause his death? Floyd's fentanyl levels were 11 nanograms per milliliter. The coroner said you just need 3 nanograms. Floyd had 11. All 34 cops came in and they said, yeah, we're allowed to use that technique. They're lying to you about this. All those cops testified lying. Derek Chauvin is back, now demanding the courts review his case, submitting a petition for post-conviction relief, saying that everything he did in the George Floyd incident was valid, backed up by law enforcement training and technique, that he was scapegoated by a corrupt media and a court system that was all too eager to satiate the mob that was rioting all across the country in the middle of an election season. And Derek Chauvin, of course, in prison for a long sentence, already tried to appeal his case, has not found success there, and is now trying a different tact. This is called a petition for post-conviction relief. And you can see in the case of Derek Chauvin, he's sending this one in to Hennepin County. They say back on April 20th, 2021, Chauvin was convicted of unintentional second-degree murder of George Floyd, 270 months in prison, and filed a notice of appeal. He said, first of all, that lower-level judge abused its discretion. We should have had a change of venue for the trial, but he denied it. The district court abused its discretion. They didn't continue the trial, and they just charged him right in the middle of the hellhole where they were burning down their cities. The district court abused its discretion. It didn't sequester the jury throughout the trial, so the jurors got beaten on by the media propaganda. The state committed prosecutorial misconduct. The district court erred when it concluded that the testimony of Maurice Hall did not fall under Rule 804B. In other words, it was too prejudicial. Erred when permitting the state to present cumulative evidence with respect to the use of force, just over and over and over. Knee on the neck, knee on the neck, knee on the neck. Abused its discretion when the state was ordered to lead witnesses on direct examination. Judge screwed up when it failed to make an official record of the numerous sidebar conferences. Abused its discretion, the judge, when it failed to allow Chauvin to exercise 4 cause strikes for clearly biased jurors. Abused its discretion when the state could amend its complaint. They added a 3rd-degree murder charge, just shoved it in. The district court abused its discretion when it limited and undercut George Floyd's May arrest. Also submitted bad jury instructions and denied our request for certain hearings, and more. Huge list of problems. We have 2 years that are required to bring this, and we're doing it now. Here's what they explain. In the spring of 2020, a bystander video depicting a police encounter was posted to Facebook. We remember. The events captured on the video, viewed millions of times across the world, 4 cops about George Floyd outside Minneapolis. The footage includes Derek Chauvin cooperating with other officers to restrain Floyd, who was freaking out, in a prone position using a knee-to-neck restraint in connection with the MRT. It's called a maximal restraint technique, and that's a tactic that was trained, authorized, and consistent with policy at the time. The technique, also referred to as the hobble, involved placing the left knee at various times on Floyd's upper back or neck area, while other officers, Lane and Kung, restrained his midsection as they awaited paramedics to arrive. Floyd died during the encounter. Now, the state came out and said Chauvin killed Floyd by asphyxiating him, suffocating him while he was on the ground, being restrained. They charged him with 3 offenses, unintentional murder, and other crimes, manslaughter, 3rd-degree murder. After a trial in court, Chauvin convicted all 3. He was sentenced on the top of the 2nd count, and the judge made an upward departure from the guidelines, okay? In other words, sentenced him to a harsher penalty than you might expect. Now, State versus Chauvin changed the fabric of the state of Minnesota. The jury rendered its verdict amid widespread protests when they were burning down cities all over America. There was international media attention, the COVID-19 pandemic, which George Floyd had, and ever-present armed security, and of course the video, right? Chauvin was doomed from the beginning. 5 years later, this case simply never made sense. None of the officers here, including Chauvin, appeared to realize that a criminal act had been committed at all. Few murders take place before a crowd of witnesses while talking with emergency personnel over the radio, but what truly sets this case apart was that in most cases, the opposing sides argue about the facts and whether there is room for reasonable doubt. But in this case, video and still frames told a single story. This case resolved around 2 issues. One was about intent. Was the restraint of George Floyd consistent with police policy? And 2, causation. Did they actually cause his death? We're going to focus on these 2 issues in this memo. How the prosecution presented false testimony in violation of the law, and how the state's medical witnesses convinced the jury that Floyd died of asphyxia, while the Hennepin County medical examiner said no. no, it wasn't asphyxiation. His heart just gave out. Now, while the post-conviction relief stage in many criminal cases is generally something of an afterthought, this court is removed from the hysteria of that day and can finally look at the facts through a clear lens. It is the first time a judicial officer can view the case without the pressure of the public mood. More than anything, this case illustrates the incredible persuasive power of video evidence and how it can be misused, and it also demonstrates the powerful effect of false testimony on the judicial process. Now, they say Derek Chauvin was deprived of his constitutional rights. He deserves a new trial, or at the very minimum, a new evidentiary hearing. Now, here are more facts. Chauvin adopts the facts in a light most favorable to the verdict as found by the Court of Appeals, with the exception of 2 sentences. Now, the encounter between Floyd lasted less than 20 minutes on that day. Officers responded to Cup Foods in South Minneapolis. George Floyd was trying to pass off a counterfeit $20 bill and steal. Cops showed up. 2 officers approached a blue Mercedes-Benz outside the store. They found Floyd behind the wheel. Almost immediately, they relayed that they thought that he was high, under the influences of drugs. Officer Lane approached the vehicle, said, "Hey, this is why we're here." Floyd refused to exit the vehicle. Lane drew his firearm and demanded he exit. Floyd continued to refuse. Lane replaced his firearm and then prepared to physically remove him. At this point, a physical struggle lasting 45 seconds ensued. Officer Kung noted the difficulty of Lane in getting Floyd subdued. He ran over to help. It took both men to successfully wrestle Floyd out of the car and secure his hands behind his back. Once handcuffed, Kung waited with Floyd on the sidewalk while Lane gathered information, and then Floyd was led to Squad 320. As the 3 approached Squad 320, Floyd became progressively and visibly more agitated while he shouted at the officers and breathed more heavily. Another physical struggle ensued while Floyd refused to be placed in the rear of the vehicle. Officers Chauvin and Thao, who had arrived moments earlier, approached the vehicle to assist the other 2. For roughly a minute and a half, a full-blown wrestling match ensued. 3 officers had to work together to bring him through the back of the vehicle and onto the ground. Floyd began saying he could not breathe while in the rear of the car. Said that over and over. "I can't breathe, I can't breathe." And he was not being pinned on anything. No one was on him. Floyd continued to resist physically. He kicked Chauvin's body-worn camera off his chest. 3 officers were ultimately successful in bringing Floyd through the rear of the vehicle and onto the street. Then 3 of them cooperated to restrain him while Thao managed the growing crowd. In executing their restraint tactics, Chauvin placed his left knee on Floyd's upper back or neck area, depending on the perspective of the video. His right knee was primarily on Floyd's left arm. While Officer Kung restrained Floyd's upper legs and butt, and Lane controlled his legs to restrict his ability to kick, they locked him down. Now, as seen in the video, Chauvin's position did not substantially change for the entirety of the application. They awaited for the cops to come up. Now, fire and paramedics were initially dispatched under Code 2. Officers had concerns that Floyd had suffered a mouth injury and was under the influence of drugs. The officers upgraded the urgency to Code 3. They said, "We need immediate assistance." The video evidence revealed that Floyd was held in place for more than 9 minutes while Thao controlled the crowd. The placement of Chauvin's left knee remained consistent, as did the positions of 2 other officers as they continued their restraint. Now, the jury was told at trial by the state, the prosecutor's expert witnesses, that the video reflected Floyd's death at 20:24:53. At 8:27 p.m., paramedics finally arrived to transport Floyd to the hospital. They were unable to detect a pulse when they arrived, and they began care in the ambulance. Floyd then arrived at the hospital, 8:53 p.m. 2 doctors attended to him, Ashley Strobel, Bradford Langenfield. Strobel was the supervising physician. Langen just got his license to practice that same month. Dr. Strobel, Ashley, was directly supervising Dr. Langenfield, and he provided aid to Floyd. Now, at trial, Ashley, the doctor, explained that the procedures that he undertook, so it's a dude, I guess, while attending to Floyd in the emergency room. And his conclusion, he said Floyd was in cardiac arrest when he came to the hospital. He examined Floyd's abdomen via ultrasound, noted no evidence of hemorrhage, no obvious significant external trauma that would have led to any bleeding. He explained that cardiac arrest could be induced by several things, including drugs. Specifically, he told the jury that fentanyl, methamphetamine, or a combo of both could cause cardiac arrest. But at the time he rendered care to Floyd, he didn't know about any drugs. After 30 minutes in the emergency room, he pronounced Floyd dead. Strobel and Langenfield, the doctors, they came to the same conclusions at the hospital, that cardiac arrest and acidosis are potential causes of death, and they identified severe agitation that could cause cardiac arrest, like wrestling with 3 cops in the back of a car. They agreed that the mechanism that caused his death was unknown. Now, prosecutors met separately with each physician before the trial. Each was shown the entirety of the videos during their meetings with the state. At the time he examined examined Floyd, Langenfeld had not seen the video. After being shown the video, he stated that what he witnessed in the video is the knee decreasing air and oxygen that killed him. Ashley, though, the other doctor, stated, well, I can't determine the cause of death from watching the video. What happened? They brought in the new doctor, Langenfeld, the brand new guy who just got his license that month. He comes in, he told the jury, saying, well, I saw the videos and I agree that cardiac arrest and death by asphyxia was one of the more likely possibilities. So 2 doctors examined Floyd the night of his hospital arrival. The new guy says probably asphyxia. The experienced doctor says you can't come to that conclusion. They boot her, have the other guy testify. Then we saw this guy, Andrew Baker, who gave great testimony. Dr. Baker performed the autopsy on George Floyd. He told the jury that he was aware that at least one video had gone viral on the internet, but he said, I intentionally chose not to look at it until I had actually examined Floyd. I did not want to bias my exam by going in with any preconceived notions that might lead me down one path or another. Now, I did see the entire video the world saw later that day after Floyd's autopsy. I did not release his body until the following morning, so had I seen something on the video that triggered yet another thought in my mind, I still had chance to act on it. Baker found no medical evidence, the guy who did the autopsy, supporting the conclusion that he died of asphyxiation. No medical evidence. I don't know what my specific language is, but yes, that is what I conveyed to them, was the lack of anatomical findings that would support that conclusion. Didn't die of asphyxiation. Dr. Baker called the prosecuting attorney assigned to the case, Amy Sweesey, after he finished the autopsy. Amy said, he called me later in the day on that Tuesday, and he told me there were no medical findings that showed any injury to the vital structure of Floyd's neck. There were no medical indications of asphyxia or strangulation. He said to me, Amy, what happens when the actual evidence doesn't match up with the narrative that everyone's already decided on? And then he said, this is the kind of case that ends careers, or makes them, if you're on the right side. Neither this conversation nor an earlier conversation that took place before the autopsy was performed were even disclosed to the defense. The results of the autopsy showed Floyd suffered from severe heart disease. All medical experts agreed upon that on trial. 75% proximal narrowing of the left anterior descending coronary artery. His tubes were clogged 75% of the way. 75% mid-narrowing of the left anterior descending coronary artery. 75% narrowing of the first diagonal branch. 90% narrowing of the right artery. Dude's closed, like locked down. He told the jury that he had certified deaths due to atherosclerotic cardiovascular disease under similar conditions, okay? This will kill you. Then when you're fighting 3 cops because you won't comply in the back of a car, it's not a good situation for you when you're also cracked out on drugs. Insofar, 90%, okay, cannot go through. Try that with anything. Get 90% out of your shower. See how that feels. Insofar as arrhythmia, Dr. Baker explained, well, an arrhythmia is an electrical phenomenon. It's not an anatomic one. So I can never really diagnose arrhythmia post-mortem. We have to just infer that the circumstances from the condition of the coronaries. The coroner, he testified that Floyd's heart was also enlarged by weight. And it turns out that the weight of a heart is a very good predictor of whether the heart is normal or not. People who have high blood pressure for a long period of time, their heart will actually get heavier. Now, he also further testified, he said, I did not notice any acute injury to the brain in the physical sense of trauma, nor did I note any injury to his brain in the sense of it being deprived of blood or oxygen, which you would have from asphyxia. Now, Floyd's blood was submitted by Dr. Baker for an expanded panel toxicology screen as part of the death investigation. The results of the test led Dr. Baker to conclude that both fentanyl and methamphetamines were contributing factors in the death of George Floyd, agreeing that he had certified deaths by fentanyl overdose where he had seen levels as low as 3 nanograms per milliliter and possibly lower. Floyd's fentanyl levels were 11 nanograms per milliliter. The coroner said you just need 3 nanograms. Floyd had 11. Ultimately, Dr. Baker's scientific examination led him to conclude that Floyd's death was a multifactorial process. As he explained to the jury on direct exam, and I remember this testimony, it's kind of seared into my brain. I don't know if you remember it, but he was like kind of struggling through it. He's like, he knows that he was giving an answer that was not publicly acceptable, but the guy did it anyway. So cheers for Dr. Baker. Says, okay, so Dr. Baker, testimony. Can you tell us how it is physiologically that the subdual restraint and the neck compression caused Mr. Floyd's death? Well, in my opinion, says the coroner, the physiology of what was going on with Mr. Floyd on the evening of May 25th, you've already seen the photographs of his coronary arteries, so you know he had very severe underlying heart disease. I know that we specifically got to it, counselor, but Mr. Floyd also had what we call hypertensive heart disease, meaning his heart weighed more than it should. So he has a heart that already needs more oxygen than a normal heart by virtue of its size, and it's limited in its ability ability to step up to provide more oxygen when there's demand because of the narrowing of his arteries. Now, in the context of an altercation with other people that involves things like physical restraint, that involves things like being held to the ground, involve things like pain that you would incur from having, your cheek up against the asphalt, an abrasion on your shoulder. Those events are going to cause stress hormones to pour out into your body, specifically things like adrenaline. And what that adrenaline is going to do is it's going to ask your heart to beat faster. It's going to ask your body for more oxygen so that you can get through that altercation. And in my opinion, the law enforcement subdual restraint and neck compression were just more than Mr. Floyd could take by virtue of those heart conditions. Now, Dr. Baker, as the chief medical examiner, is required by law to perform the death investigation. He must furnish to the Department of Health information related to the cause of death. The data that he provided to the state said the cause of death was cardiopulmonary arrest, complicating law enforcement subdual restraint and neck compression as the cause. That was on the death certificate. The manner of death was homicide, Dr. Baker explained. So as a medical examiner, we apply the term homicide when the actions of other people were involved in the death. It's a medical term, not a legal term. Other people were there, he died. Now, I don't even know what the legal standard is, but they're two different worlds. What did you mean by the word complicating? Well, complicating means occurring in the setting of. Okay, so cardiopulmonary arrest occurring in the setting of a law enforcement restraint. Okay. Now, at trial, Dr. Baker was asked to opine on the video and the deployment of the knee on the neck, he said. So, in my impression from the video, I want to be very clear. I have no special expertise in looking at videos. I'm just looking at them as another person trying to figure out what happened. In my opinion, it would appear that Chauvin's knee was primarily on the back or the side or the area in between Floyd's neck. Not even on the neck, according to the guy who actually did the autopsy. Now, they brought in a bunch of other people. 4 expert witnesses also came in to talk about causation. Dr. Tobin and many others. They all came in and they said, no, it's definitely the knee. None of them, though, performed an autopsy on Floyd, nor did they even rely on Baker's medical examination to come to their conclusions. Baker didn't seek out their info. They all just kind of watched the video and came to their own conclusions. Tobin was the first causation person to come out and testify. Never testified in a criminal trial before. He was contacted by the state. He said, I've watched the video hundreds of times. He agreed that he watched them from all different angles, and I watched a lot. Now, his credentials don't say anything about him being a video expert at all. He didn't use any special images to analyze the videos, but he came out and told the jury. He just said, I watched a lot of these videos. Chauvin's left knee is on his neck, and he says, I've calculated it. It's 90% of the time. There's certain times where you don't have a good view. So I think the knee was up there for 57% of the time based on my mathematical formulas and watching the videos. Now, he was unsure of Chauvin's weight, so he's doing these calculations, and he's trying to come up with pressure and just made up a bunch of stuff, talking about these height, weight, and gender, and says airflow was totally shut off. Then he went through another series of equations. He said, by the time Chauvin lifted his knee, not one molecule of oxygen would have remained in the body. That's pretty amazing. Not a single molecule of oxygen in the entire body. Wow. And just said a bunch of nonsense. And they repeated all of his statements during closing arguments, and he said he got strangled. His conclusions were the opposite of what Dr. Baker said. Here's several examples. Baker said Floyd's very severe heart disease mattered. And Tobin basically said, differently. Baker says fentanyl and methamphetamine were factors. Tobin, no, there was no evidence he died from meth. There's no evidence fentanyl affected his ability to breathe, and on and on. Okay, total disagreements between the experts. But then they brought out another doctor, Dr. Smock. He says he's got some forensic training and he's a pathologist. What did he get his evidence from? Videos. He watched videos multiple times. He says he could tell by the video that fentanyl didn't cause his death, watching the videos. Asked whether any evidence was found in the autopsy about significant use of force, he says, well, I don't even need to read the autopsy. There's no evidence in the autopsy, but it's on the videotape, sir. I watched the video. He admitted that there was no other evidence of airway obstruction other than what he saw on the video. All these experts. Dr. Lindsay Thomas comes in. She's working for 37 years. She's done 5,000 autopsies. Didn't examine the report at all. Instead, what did she look at? Videos. Many videos. I watched a lot of videos. And these videos are unique. And I can understand what's happening physiologically in a person's body by watching a video. Cardiologist Dr. Jonathan Rich also said the same thing. He watched the videos from many different angles and he concluded low oxygen levels because he watched a lot of the videos. Now, all of the videos show proper training techniques. 3 witnesses with authority over these training tactics would testify at trial. Arredondo was there. Blackwell also was there. And there were other relevant policies about how all this works. You can see it right here. Okay, they're in handcuffs. What What now? Oh, look at that right there. Knee on the neck. Right there. Look at that right there. From their friggin' PowerPoint slides. Okay, they're in handcuffs. Now what do you do, police officer? 1. Sudden cardiac arrest typically occurs. They even mention that. Place the subject in a recovery position to alleviate positional asphyxia. Once in handcuffs, get EMS to the scene, sign a transport hold on these individuals, and complete a report. So Chauvin was doing exactly what he was trained to do. Now, here's another one. Right there. Looks exactly like that right there. The state filed a motion in limine to keep this out. The state said, we don't want you. They're prosecuting Chauvin. They want to convict him. Don't bring that in as evidence, that he's allowed to do that. The state filed a motion to keep that evidence out. Their argument is that Chauvin didn't see the presentation. So how can you prove that he saw that PowerPoint slide? So they wanted to keep that out. The state told the trial court that Chauvin would not have received any training like this. And so the state was quoting from some emails. On March, though, a month after the state filed its motion, another inspector met with prosecutors to prepare for the trial. She told those present that the neck restraint was technically authorized, but would have stopped it if she had seen it performed on May 25. Okay, so they're all even admitting it was technically authorized. The state kept it out of evidence successfully, but trial counsel did not learn of that until 2 weeks after voir dire had begun. Trial counsel could only impeach with Bates, but you can't use that in the trial, right? So the jurors didn't see it. Now, in the wake of this ruling, prosecutors called Arredondo to testify. They presented exhibits and said, as you reflect, I must ask you, is this a trained technique? He says no. So it's your belief that what Chauvin was doing violates department policy, even though you just saw the slide. I absolutely, says a cop backstabbing Chauvin, I absolutely agree that that violates our policy. When I look at the face of Mr. Floyd, that is not light pressure. Another cop stabbing Chauvin in the back. Looking at Exhibit 17, you say this is not a trained technique? Correct. It's not. Floyd is dying. Blackwell, another cop, takes a stand, also stabs Chauvin in the back. I'd like you to look at Exhibit 17. Is that a trained technique that you just saw Chauvin, the actual photo of Chauvin and Floyd? No. Why not? Well, it has to be consistent. So per policy, a neck restraint is not allowed. Well, I don't know what kind of improvised position that is. That's not what we're allowed to train on. Literally in your slides, bro. The next day, Mercil was asked, sir, is this a neck restraint? No, sir. Has it ever been? No. Not a neck restraint? No, sir. No, we're not allowed to do that. State once again made no attempt to correct it. And then they put this slide up. All of them say unreasonable, illegal, shouldn't have done it, shouldn't have done it. All these cops stabbing Chauvin right in the back. All these chiefs abandoning their cops. Then on October 17th, others published their lying. This was a book critical of testimony. The book made 3 statements seemingly saying that they're lying. In late 2024, Katie Blackwell filed a lawsuit. And now, since this happened, 34 current or former officers have come forward to give us a sworn statement. All 34 cops came in and they said, yeah, we're allowed to use that technique. They're lying to you about this. All those cops testified lying. Not only was the knee to neck trained, it was commonly used. Somebody submits an affidavit. Yeah, we used it all the time. Besides me, someone else says, numerous police officers participated in the training. This wasn't a secret. I know numerous officers that were trained to place their knee on the side of a neck. It was common knowledge. It was trained in the open. Someone else, besides me, we were all in this training. And besides me and many others, this wasn't a secret. It's necessary for the officer to pin him on the ground. They all said it. Now, the suit came out, was dismissed, and there's several images of these officers using this technique, and they've made findings. In fact, yeah, they did make findings. MPD policy, Minneapolis policy, was at odds with their testimony. They lied about it. They said, this is not what we train at all, but they have it. In fact, training materials from 18 and 19 show images of it. 34 officers swore that they were trained with this technique, and so the other cops lied, in my opinion. Katie Blackwell also signed a declaration, and at the close of trial, the jury was instructed erroneously. And so this was a big problem. Now, we need to correct this record, and more in the argument comes down. They say the trial court failed to deliberate or delineate between the practice of medicine and video viewing. It abused its discretion. There was medical evidence that was presented, but there was no medical evidence of asphyxia at all. Everybody just said, I watched the video a lot. So you have to be based off evidence. The state's cause for causation was subjective. In the words of Dr. Baker, the only person who actually examined him, he said, the videos should have no relevance. This means either one of two things. Baker was lying, he wasn't, or Tobin and the other experts were. Physicians cannot watch videos and come to medical conclusions. Now, this is correct in Minnesota. It's been widely recognized in other jurisdictions. There's a line between video and reality that this court never indulged in. Foundational reliability is a concept that needs to be introduced, and video is direct evidence of what happened in the video, but it's circumstantial evidence of causation. You can watch a video a bunch, but it can't help you identify whether his heart failed or whether he was asphyxiated. You need some more evidence other than that. None of the video evidence sheds any light of what happened inside his body, including the chemical reactions in his blood, brain, arteries, and more. How much air was in his lungs? Expert testimony needs to come in to establish causation, and they couldn't do that. The Supreme Court in Minnesota has held that video evidence alone, without any support of medical findings, is not adequate for causation. That's a huge case for them. There was a school bus monitor who struck her head on the console. When the bus came to a stop, they did a CT scan. No evidence of a concussion was found. The factor was the video. The lower court came through. They said a video is not alone substantive enough. Continuing on. So the use of video evidence needs to be distinguished. You have to be clear what it's being used for. And these other experts in their testimony was not any good. Tubin came in. He created all these mathematical formulas, but it was all basically speculation. He was just trying to wrap his conclusion in some math. This isn't cutting edge scientific research. No specialized equipment was used. He slowed down, he paused, he rewound a video a bunch of different times, and then came up with justification for causation. There's also prosecutorial misconduct too. The record in this case explains how prosecutors improperly pulled out expert witness testimony for their own ends, and they have weak causation. Only thing they have are experts who watch the video. No other supporting evidence at all. There's a glaring lack of medical evidence on any theory of asphyxia. Dr. Baker didn't watch the video because he didn't want to bias his exam, and the exam showed heart problems. Enlarged heart, fentanyl, methamphetamine, adrenaline, chronic heart disease all led to cardiopulmonary arrest. Baker was careful to use each one of the three processes, explained everything that happened and how it contributed to his death. The state knew all of this, but they had to bring in other experts to undermine their own coroner. Now, Baker agreed he could not perform those calculations because they're irrelevant. Many other people deferred to the coroner, and they kept trying to discredit Baker, the guy who actually led the autopsy. So this was improper. A lot of this testimony shouldn't have come in at all. All of these statements are speculative. They lack foundation, and the judge just let it all in, speculating more testimony from the trial. And other experts shouldn't have even been allowed to come in as experts. There's this Daubert standard that we talk a lot about, which is how do you validate expert witnesses, and should they be validated at all? Prosecutors were successful in keeping images out, but Chauvin should be granted a new trial. He was following techniques that they literally trained, and he couldn't even present evidence of that. It contained 5 false answers by MPD supervisors, and prosecutors failed to correct them. Okay, the cops lied about their own training in order to satiate the media and to imprison Chauvin. So with all of this testimony now articulated, they're saying Chauvin deserves a new trial. These techniques were authorized. These people who testified about them were lying about it, and his due process rights were destroyed. His position remained the same. He was following his training appropriately, and he couldn't even talk about it. Now, this testimony took defense counsel by surprise. Katie Blackwell was the commander of the training, a key witness, but Chauvin had no way to visually demonstrate that Blackwell was not telling the truth after they came in and said he wasn't trained on this. After the false testimony, the cross-examination by the defense lasted for less than 3 minutes because they were shocked. She came and lied. Well, I can't confirm that he was personally trained on that, but the jury knew that he was up to date, but we couldn't respond to it because she just came out and essentially lied. So Derek Chauvin is entitled to a new trial. They walked through some of the bad jury instructions, and Chauvin's rights were significantly impacted. So we got to have a new trial. 34 agents, 34 officers have come out to support him. He was following lawful techniques. We were presenting actual medical evidence. We connected causation appropriately to heart disease, drugs, and more. And so we need a new hearing in a petition for post-conviction relief signed by Gregory J. Joseph in the Derek Chauvin matter. So petition for post-conviction relief. These are almost like appeals, but it's saying we've uncovered new evidence, in this case, more facts that he was actually employing a technique that other law enforcement officials had validated and approved, and Chauvin got abused. This took place in the aftermath of the Trump election, and there were people who just wanted to convict him no matter what. We went through the trial. We're happy to see that there's still some fight left in him on this one, but this appeal will likely take time, and at the moment, he's sitting in custody while the corrupt prosecutors, and it sounds like the lying cops who testified against him, all run free. Chauvin, the victim, of course, of another political propaganda operation to energize and weaponize a whole constituency in the middle of an election, and he got abused for it. So we'll keep our eye on this one. Hopefully the courts can look at this with a fresh set of eyes, but it is Minnesota. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do.